Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Let's begin with Kitab Al-Fatihah. Okay, this coming afternoon we will proceed to discuss on topic number 10, which is internet pornography and sexual offences. Okay, this internet pornography and sexual offences, they are also part and parcel of cybercrime. Especially when they are being, internet or the computer is being used as a medium to commit the crime. Okay, so throughout this particular topic, what we intend to do is basically we would like to know what is what how the law defines internet pornography, and what we will capture a little bit of the development as far as this topic is concerned, and we will look at, in particular, we will look at how our country, look at this matter as far as the legal test for pornography is concerned. So because we are using the internet, kan, and whether we will examine whether the question of whether the legal test to determine something is obscene or not, whether that is similar between the internet pornography as opposed to the the real world or the penal code definition of pornography. Yeah. So rest assured, you won't see any pornographic things in the slides. Yeah. But we will be looking at this issue from a legal point of view, and from there we will compare with UK and US as well. How does UK um, look at or view the legal test for internet pornography? So because we know that different continent or different countries, they might have different tolerance over certain, over pornographic materials. Some countries, like Muslim majority countries, pornography is, even the slightest of showing of the skin might not be, or is, they are not tolerable to the society, or perhaps the law has prohibited the showing of even indecent pictures, not even pornography, but just indecent pictures. People or the regulator might feel that this should be censored. But in some countries, like in Western countries, maybe they think um, um, certain, what would be indecent to us might not be so sensitive to them, so they allow certain kind of content under the purview of arts, for example, arts, and so in that, or maybe because the viewers are adults, mainly adults, so in that sense they allow viewing of certain kind of obscene material, because this is not for children but for adults, so it has been restricted in such a way. So that is because of the different regulations, different style of regulation. Yeah, we will see whether the legal test adopted by these other jurisdictions, how can they, whether they fit, or whether they, how can we compare with ours. And we will also see, because pornography is not really a new issue. It's just that the use, when the medium was to transmit was the internet. So we will see how the court look at this, how the court differentiate between the real world, the usual type of pornography against the one on the internet. So ada beza tak dia punya elements or the legal test used, yeah. So and then we will come to yeah, apa yang dindong-dindong ni. Okay. We will come to the issue on child sexual offences, yeah, which we will look at the offences relating sexual offences concerning children, yeah. In I will particularly discuss on the sexual offences against children act 2017, yeah. So I think that that act is not discussed in your criminal law class. So we will look at that one, and we will see particularly on the issue of child grooming. Sebab why we look at that is because there has also been an issue whereby the internet or the social media is being used to groom children. So children knew somebody from the social media, and then they meet in the real world, and because of that they were raped, or maybe they were things happen, bad things happen to them lah. So this new law still we can say it's quite new, 2017, has been enacted lah to try to cater to this problem, yeah. Okay, let's look at definition. There are many. If we look at definitions, example here, the meaning of obscene material has been defined by the Supreme Court of the United States. Material which deals with sex in a manner appealing to prurient interests. Yeah, and in another case, Miller and California, the Supreme Court of US came up with the definition of pornography, which is a description of prostitutes or prostitution, and secondly, a depiction of lewdness, or a portrayal of erotic behavior designed to cause sexual excitement. And then there are two categories, softcore, hardcore. Softcore ni macam ringan-ringan lah macam tu. Yang hardcore ni yang ganas-ganas macam tu. Aku tak tahu ganas mana lah kan. Okay. Lepas tu why regulate, on the question of why regulate, we as Muslims we know that these kind of materials will lower the right thinking, or our mental thinking, so much so that there has been prohibition, the prohibition the prohibition against pornographic viewing or participating ni is actually in line lah with the Quranic instruction to avoid zina. Avoiding zina is actually the Quranic ayah that has been cited to so-called to prevent Muslims from being exposed to this. But from the scientific point of view, there have been opinions from scientists saying that it leads to addiction, and because when it leads to addiction, this can become to a certain extent, when someone is so addicted to pornography, it is said that they require a more higher level of stimulation in order for them to be to be stimulated lah. And then it is also said that being in an intimate relationship is no longer sufficient to satisfy his or her desire. So they want something more rougher or explicit sexual material to turn them on, and this is particularly very problematic if the person is already married, and this can actually be the effect is that it can cause a breakdown in marriage relationship, which could also lead to divorce and etc. Yeah? And it is also said that the next level of addiction is desensitization. They are they are less sensitive to sexually arousing material, and they are, and the most serious level is when these persons they act out sexually. This can actually uh, cause sexual crimes and serious social problem. Yeah? So this is from the scientific point of view. They are thinking this word the because the addiction can trigger this kind of behavior, which is why from the social point of view they think that this should be prohibited lah. Tapi we from the religious point of view we know that this is something that God has commanded upon us to avoid zina, and any acts in connection to that should be avoided. Yeah? So as far as regulatory challenges is concerned, yeah, people might think that, or the data has shown that United States has the largest porn industry in the world. They profited $1 billion, but uh, bear in mind that there has also been an attempt to regulate the porn industry in the United States, because not it seems like not everybody loves the industry lah dekat situ. So they try to, there has been a steady move to outlaw obscenity. So this was done through the case of Rex against Siddeley. And then we will look at other jurisdictions juga lah kat sini, US, UK and Malaysia, as I mentioned earlier lah. So as I said earlier, there has been this move to limit the access of pornography, and then the thing is that at the same time it is also generating a 90 billion worth industry. So to a certain extent there are certain portion of the industry that or the people, they are trying to seek protection under their United States Constitution lah. So they what I mean, the adult industry ni is trying to hide behind the pretext of freedom of speech. So when there was this attempt to shut down the industry, there will always be people who go against this, and they say that this is our right to freedom of speech under the Constitution. So then it becomes the challenge becomes problematic lah. And then under the case of People Against Freeman, there was an attempt to shut down the US adult industry in court. But this also becomes it's not really successful. In this case, Freeman, he was a director and producer of pornographic film, and then he was charged with pandering. This is actually recruiting people for the purpose of prostitution, which is contrary to Section 211I of California Penal Code. Then upon appeal to the Supreme Court, his conviction was overturned because here the court differentiated between prostitution and pornography. Freeman here, if Freeman hired adult actors for his personal sexual satisfaction, then he will be caught under the offense of Section 266, which is for prostitution. But in this case, he did not do that for his own personal sexual satisfaction, but for business. So in this case, the court said that his action should be protected by the free speech principle. So this case, it becomes the protective net for the adult industry to operate legally in the US. But they have some regulations like this one, Title 18, US Code of Regulation. They say that all producers of pornography industry, they have to create records that all performers no person shall be under 18 years old. So dia ada quite a strict law lah to regulate the industry. So yeah, whether we can take into consideration the approach from the US, it might not be so suitable to our society. So in the US, to qualify a material as obscene, Supreme Court of the US agreed to use the contemporary community standards. This was held in the case of Miller against California. So the test is, this is the test. If you look at the material, the work or the film, whether a particular work can be legitimately restricted by the state, okay, you have to consider the work taken as a whole must appeal to prurient interests as determined by average person applying contemporary community standards. The work must depict sexual conduct in a patently offensive way, and the work, when taken as a whole, must lack serious literary, artistic, political, or scientific value. If this is satisfied, then it means that the work or the film too can be legitimately restricted by the state. So this is the elements which has been inspired by the which has been held in the case of Miller against California. So it was said that Miller test has provided greater freedom for the US court to prosecute obscenity cases. Although the issue of community standards may be of concern, but we are actually looking at because the problem is that the obscene content can be accessed from any part of the world. So again, and another issue is that you cannot apply, when you talk about community standards, it means that what would be acceptable for that community. Macam for example, you're talking about Malaysia. Malaysia might not tolerate having advertisements with women's wearing underwears, or even maybe some men wearing very improper underwear, for example, so that too much skin to show. But in other part of the world, maybe this is okay because this is for modeling purpose and whatnot, isn't it? So one cannot apply the same community standards in the US with that in Malaysia, because of the difference in societal values. So that is the Miller test. In the UK, they have laws to regulate pornography. It's pretty, I think they have two laws. One is Obscene Publications Act, another one is Criminal Justice and Immigration. Mere possession of obscene article alone is not an offence under the UK. But if you publish or if you sell for profit, then that would be an offence. Obscenity has been defined under Section 1 of the Obscene Publication Act. So this is the definition. An article should be considered obscene if its effect or the effect of any of the items, if taken as a whole, it tend to deprave or corrupt persons who are likely, having regard to all circumstances, to read, see or hear the matter content embodied on it. Dia punya definition macam a little bit open, but the idea is that if you look at the material, it will corrupt your what you see lah, your minds. And then this position, or the definition has been it originated from the case of Regina against Hicklin to determine whether a material or a content is obscene. The courts will have to determine whether the tendency, UK dia pakai lain sikit, whether the tendency of the matter charged as obscene is to deprave and corrupt those whose minds are open to such immoral influences, and into whose hands a publication of this sort may fall. So dia tengok dia punya tu, whether a material is obscene, they will see whether the material has the tendency to deprave and corrupt the minds of those who are exposed to the immoral material. So this it is being applied both to the obscene material in the printed form as well as in the digital form. Yeah? And Section 2 of the Obscene Publication Act criminalize publication and dissemination of obscene articles regardless for profit or no profit. Yeah? Mere possession is not outlawed. Yeah? To publish here means, yeah, to distribute, circulate, sells, lets, yeah, on hire, or you give or you lend it to someone. So this is the definition. Yeah? So any UK netizen who publish obscene article for gain to himself or to another person will be criminally liable under Section 2 of the Obscene Publication Act. Yeah? Ni UK. Yeah? And then UK also recognize extreme pornography. What is extreme pornography? This is actually under Criminal Justice and Immigration Act. Extreme pornography ni, the definition is it is an act, yeah, an act which threatens a person's life, or maybe an act which causes serious injury to someone's anus or breast or genital, an act which involves sexual intercourse with a human corpse. So this, if there are this kind of pornography, the law in UK label this as extreme pornography, yeah, and it is criminalized lah, yeah. Okay. The UK courts does not consider internet as a new medium, yeah, that created legal lacuna so far as possession of obscene, extreme, and child pornography is concerned. Yeah? Okay. On the offense of possession, this is more focusing towards child pornography or child sexual abuse images. Yeah. So possession of child sexual images ni, the UK law gives it a very serious concern. Yeah? So for example, Regina against Fellow and Arnold, the Court of Appeal held that the acts of uploading child sex abuse image into a password protected online archive, it is sufficient to constitute the possession offense. So therefore it is wrong under the law. Even though people might say, I'm not publishing it, I'm just uploading this photo into a password protected archive. Supposedly nobody can see it. But the law in the UK, they view child pornography very seriously. I think this is similar to our country as well. Another case is Atkin against Director of Public Prosecution. Such possession of indecent child images, it must be accompanied with the knowledge of its existence. If they were stored in a computer cache not unknown to its owner, chances are he may not be guilty of the possession offense lah. So this is not really a strict liability offense. What about viewing? In the case of Regina against Harrison, the act of viewing indecent child images, it was held to be able to constitute the making offense, as if you are viewing, as if you are making child pornography. Yeah? So if the defendant knew that the images will pop up and be automatically saved once seen, the mens rea was considered fulfilled. So in this case, the UK law treats child pornography a lot more serious, much more serious than the adult pornography. Yeah? Okay, let's look into pornography regulation in Malaysia. We have several laws like Section 292 Penal Code. Yeah, this regulates publication, selling, buying, whatever kind of sexual objects or films lah. Yeah, Section 211 to 33 CMA prohibits publication of indecent, obscene materials. Section 5 Film Censorship Act, yeah, also prohibit the publication of pornographic films. But in the Penal Code and the Film Censorship Act, they do not mention whether this extend to online pornography. Yeah, but we don't see any problem for the court to extend the interpretation to internet pornography. Yeah. And you might be thinking about new internet terminologies, upload, download, streaming, and we don't find this in the law, isn't it? So there has yet to be any court debates, or the discussions in the judgments about the the difference between, the terminology upload, download. Is it similar to uh, buying, selling? So this is, there can be a lacuna there, but the court which has yet to dealt with this linguistic terms, because sometimes you know um, streaming, when people talk about streaming, whether that amounts to you buying, is it similar to buying um, a particular content. So yeah, this is new terminology that has yet to be looked into. Okay, so the Penal Code has made no efforts to define pornography. We have seen earlier on the US courts, they have tried to define what is pornography and obscenity. Similarly, under Communication Multimedia Act, it also does not define what is. We don't find any interpretation of what is pornography. How is it different with obscenity? Which one is higher? Which one is lower? But we can see this in the Content Code. Yeah? Content Code has defined apa ni apa ni pornography ni. Okay, this is section 292 Penal Code. Yeah, Penal Code. Whoever sell, lets to hire, distributes, public, blah blah blah, ni semua is a commits an offence. Section 211 applies to the content application service provider. No, there shall be no content application service provider that provides content which are indecent, obscene. Okay. And 233 is about improper use of network facility, and meaning that there shall be no comment, no publication, suggestion, or communication in particular which is obscene or indecent, intending to annoy another person. Okay, this is Content Code, section 2.1. Define the meaning of indecent content as offensive, morally improper, and against current standards of accepted behavior. And this includes nudity and sex. Yeah, the code did not clarify on the extent of nudity. Yeah, whether partially nude can be tolerated or not. Okay, I just want to update you on this. There has been, if you still remember, I advertised in our group about the recent Content Code 2021 revision, kan. So in this coming revision, what they intended to do is that on the offense of on the point of pornography ni, or apa nudity ni, the content forum has received feedback that they think that if they kan sekarang ni dia punya ni, they don't allow nudity at all, not even the slightest sense they don't allow. But for reasons of arts, science, and education, they are seeking the public's opinion on whether the provision should be revisited, and then maybe they should put it like nudity is allowed only for reasons of science, arts, and education. They have shown to us at the, siapa yang attend meeting tu tengoklah, they have shown to us a picture of an example of that. Ditunjuk agak satu gambar, and then when we view that, there's a picture of a lady lah. Saya tak ingat gambar apa. Tapi when we view that picture, it doesn't look like scientific or education. It looks improper lah. It looks indecent. So according to them, this to allow some rooms lah for advertisers ke content creators if they want to have this kind of show this kind of content. This is what it means by um, allowing it on the ground of science ni lah, science ke apa ni. So I suggested to the content forum that I think you should not say nudity is allowed for reasons of science, blah blah blah. I think you should maintain, sebab orang akan guna macam, people like to read only 2 or 3 words kan, or maybe just the heading. So you might be trapped and say, anyway, content code is a self-regulation industry code, isn't it? So yalah, macam it will become a guideline for the industry. So if you put like it's allowed, orang tak akan baca yang belakang tu lah. You might as well you be safe and say it is not allowed, but except for arts or science or education content. Maybe that also requires some kind of censorship lah for them to see. Yeah. So yeah, this is the current update lah on this part. Yeah. And then we have the Film Censorship Act 2002 that criminalizes the act of possession, keeping, custody, control, produce, selling or hiring obscene films. Yeah. Okay, so it's clear lah. It's clear in Malaysia that pornography and obscene materials has been made illegal in Malaysian law. So the obscenity test, we don't find, how do we determine whether a material is obscene or not? We don't find this in the penal code, we don't find this in the CMA, but we can find this in the content code. I will cite one case after this. Yeah. But before that, we look at the content code. Yeah, content code explain obscenity by outlining the following characteristic. Section 3.1. Yeah? To qualify a content as obscene, it must cause a feeling of disgust by reason of lewd portrayal. Second, it is essentially offensive to one's prevailing notion of decency and modesty. And third, the content having a negative influence and corrupting the minds of those easily influenced. Yeah? So the test is section 3.1. The content has the tendency to deprave and corrupt those whose minds are open to such communication. Yeah. But take a note here that the courts do not refer to content code when referring to legal questions, because it only acts as a guideline for the communication and multimedia industry. Yeah. But we see that this is similar to the UK case just now, Regina Hicklin, if I'm not mistaken. It's similar to that case, the test, obscenity test. Okay, just to refer you to one, it's actually a case regarding pornography in the form of book. Yeah. So this, I just want to highlight to you the test in which the court used to determine whether the material is obscene or not. In Muhammad Ibrahim against PP, we can see that the test adopted in content code just now was similar to this. To qualify a material as obscene, the courts will have to determine whether the alleged of obscene material could deprave and corrupt the minds and lead to more immoral influences. The test is similar to the one stated in content code. Further, section 3.5 part 5 of the content code also says that what is illegal offline remains illegal online. This, in a way, they are saying that you don't treat cyber world as a different safe zone to commit crime lah. Okay, in the case of Muhammad Rizal against PP, this was actually, the case is about pornography in the form of VCD, but we can actually, people can this particular VCD ni has actually been uploaded on the internet. So there has the material. Actually, this Rizal ni he was charged under Section 292 for making a VCD lah for containing sex scenes. One with the scenes was recorded with his wife and then also and several women, and then he was charged, and then he didn't have any intention to publish it for commercial purpose. He kept it for his own personal use, but when he said that when he didn't know when the particular VCD was leaked to the public lah. So now at the High Court, he at the Sessions Court, the accused was found guilty, but when the matter was appealed to the High Court, the judge overturned the decision, because the High Court basically found that the lower court had erred in law when she failed to ascertain whether Rizal had made or produced the recording for public distribution. So this is actually an important element under Section 292 of the Penal Code, because 292 is mainly it prohibits this publication of this kind of material for public distribution. So according to the judge in the High Court, the important element in the Section 292 has not been established. So he was acquitted and discharged. This Lee Mei Ling against PP is actually the famous case of Alvin Vivian couple. First, this actually happened to 2012. Actually, first they made several sex video in their blog. It's actually their personal blog. At that time, they were girlfriend boyfriend lah. And then later they also made poster. Poster tu macam inviting people during Ramadan. Actually they inviting people to buka puasa with bak kutih. So if you look at Google image, you try to Google, I think you can find the picture. So bak kutih is actually a pork, it's kind of soup, pork soup macam itulah. So because of that, both of them were charged with first one is Film Censorship Act, and then this one is for the pornographic, and then the penal under Section 298 for Penal Code for promoting enmity between races, and then for sedition. Of course, when the matter was ongoing, this Alvin he absconded to United States, so now leaving the girlfriend alone lah, facing the charges. Finally, the girlfriend was found guilty for the charges. Okay. This is the difference, just to show to you the difference of the test, obscenity test used between UK, US, Malaysia. UK and Malaysia quite similar, quite similar tests. Whether the content tends to deprave and corrupt the minds of those who are exposed to it. But for US, they use Miller test. Miller test. Okay, before I move to grooming and child pornography, any question?
No questions.
Yes?
No questions for now.
Oh. Okay, for grooming and child pornography, this is the part where we will look at some specific laws concerning this matter. Sorry. Okay. What is grooming? Grooming it is the act of befriending or establishing an emotional connection with the child in order to lower the child's inhibition in the preparation for sexual abuse. Child grooming occurs when an adult befriends a child and creates an emotional connection with the intent to sexually abuse the child. Yeah. So this, I think, this is yalah, the sometimes if this happens on the social media, we can see that from the reports that the adult try to either the adult try to behave like he is also a child, and then he try to befriend the other victim children tu, or maybe he behaves like apa tu, like a step brother or step sister, something like that, in order to establish trust with the child. So this is broken to three parts. Yeah, communication, grooming, and meeting in person. Communication may happen online. Grooming can also happen online. But when these two activities were successfully engaged, then the predator can usually they will ask to meet in person, to meet the child in person. That is when sometimes the child is kidnapped or maybe lost. Yeah. The Sexual Offences Against Children Act, knowing that this is a problem even for our society, the Parliament has enacted the Sexual Offences Against Children Act 2017, yeah, to regulate child grooming, yeah, to criminalize child grooming in Malaysia. Yeah. So let's look at Section 11. Section 11 prohibits any form of sexual communication with a child or encouraging a child to have sexual communication. Yeah, but Section 11 Clause 3 provides an exemption if the communication was for the purpose of science, medicine, or education. Yeah. Section 12 makes it illegal to communicate or pretend to be someone else to sexually communicate with a child, even if they never actually meet in person. So this act, it it tries to stop the process, the grooming process, even from the very beginning. So sexual communication itself has been made an offense under Section 12. Yeah. Any person who communicates by any means with a child with the intention to commit or facilitate the offense under Section 567, and we will see after this, commits an offense under this particular law. And also liable to whipping. Kat sini ada sebat. Okay, to give you an illustration, okay, an adult's example, an adult tells a child, okay, I'm shooting a film and I want you to be the star of that film. And it turns out that the film is pornographic. This is guilty, under the law. The adult is guilty. The adult sends a text to the child. Hey, why don't you come over to my house tonight? With the intention of molesting the child. This is also actionable and guilty under the SOAC. Section 13 describes the situation when the adult actually meets up with the child. Okay, this is when they are taking steps to meet the child. So example here, an adult man pretends to be a 14-year-old boy in order to develop an online relationship with a 13-year-old girl. He then arranged to meet her in the mall with the intention of consummating the relationship somewhere else. This is an offense under Section 13, punishable up to 10 years jail and whipping. On the position of trust, the law also recognize, if let's say the grooming is done or is being conducted by someone in the position of trust, maybe relative, for example. So Section 16 actually allows the court to sentence someone who is in a position of trust with the victim up to 5 years in prison and at least 2 strokes of cane. Cane on top of whatever punishment already being given. So here it means if the offender is katalah is an uncle to the child, and he has been found guilty for several offences under the SOAC. But because he is in a position of trust, the court can actually add up, yeah, his sentence under Section 16 to top up, whatever that has been given to them lah. Example here, a stranger who sexually assaults a child would be guilty of a Section 14 offence. But if, let's say, a teacher sexually assaulted a student, and the teacher in this case will be guilty of Section 14 and Section 16 offence. Yeah. So the position of trust is for example, teacher, student, doctor, patient, parent, child, relative, child, and so on. Yeah? Okay, Section 4 of the Sexual Offences Against Children Act, from Section 4 until 10, it concerns with production, distribution, and viewing of child pornography. So Section 4 defines what is child pornography. This is the statutory definition. It means any representation, visual, whether it is visual, audio, sometimes it's just audio, tak ada gambar, written, or a combination of a child engaged in a sexually explicit conduct, of a person appearing to be a child engaged in a sexually explicit conduct, blah blah blah. Section 5 talks about making. It prohibits any form of involvement in the making of the child pornography. Section 7 prohibits using a child to produce child pornography. Example here, Kumar signs up his 13-year-old daughter to appear in a child pornographic video directed by Ali. Ali accepts the offer and hires adult-age Kevin to also act in the video. Chong is hired to edit in the post-production. In this scenario, Kevin, Ali, Kumar, Chong will be charged under Section 5 for being involved in the production, and be sentenced up to 30 years in prison and at least 6 strokes. Kumar and Ali, Kumar ni sebab bapa dia kan. Ali is Ali will face an additional charge of Section 7 for using a child in pornographic film, and be sentenced up to ni lah. Tapi selalunya as far as sentencing is concerned, the court has further discretion to combine the sentences so that the sentences will run consecutively lah. Tapi kalau selalu 30 years ni, it means life imprisonment lah. Okay, on Section 8, distributing and reproduction. So this is an offence under Section 8. As long as you are found anywhere along the distribution chain, whether you download, whether you share, you sell, then the offender can be charged under Section 8. Yeah. The law also covers people who participate in and makes an income from a child pornography related business. Ni example, Eric is an administrator of a child pornography website. Although he is only an admin maintaining the website, he does not actually make the child pornography. He can still be guilty of the offence under Section 8, knowingly making child pornography available. Okay, Section 10 clearly says that anyone who access child pornography commits an offence. Any person who access or has in his possession or control any child pornography commits an offence. If you knowingly visit the website containing child pornography, obviously you are guilty under Section 10. But there's something which is not so clear. What if you receive an email with an attachment that contains child pornography? You don't know this is child pornography, and then you didn't open it. katalah after you open it, you immediately delete it, then you may not be guilty lah of section 10 kan. But if you continue viewing, you save it somewhere else, then you might be caught under section 10. Okay, to illustrate some cases, Hillary Bungko against PP, this is actually a case whereby a child was physically sexually assaulted. Yeah, the person or the accused, touched the child's private parts, but did not have sexual intercourse. So in this case, the accused has been charged under section 14. 14, and then the accused pled guilty to all of the charges, and court basically considered lah some the as far as the sentences is concerned, the court tried to apply the totality rule, to try to so that the sentences can run concurrently. So here, appellant was had to serve 10 years in prison, and then there's the other under penal code pun ada, under sexual offences against children act pun ada. So total dia kena serve dekat situ 10 years lah, lepas tu another 20 years lah juga, plus 8 strokes of whipping order was reduced to 2 strokes, 2 stroke for each of the 4 charges. Maknanya 4 kali 2 lah, 8 kali instead of 13 times, 8 strokes of rotan. In another case, Muhammad Izani against PP. This was stepfather. Stepfather ordered the child to touch his penis, and then there was the third incident. The accused actually inserted his penis into the child's vagina. So the child didn't inform anyone about this incident, because she feared lah, because of fear. But then when at school there was this subject about health education, and then the school counselor was talking about unwanted touch, and when this was taught in class, cikgu dia tu lah, basically there was somebody who told her that about this particular matter, and then later the mother of the child brought her to the hospital lah. So later it was after the examination, and then according to the experts, tak nampak lah macam ada kesan rogol and whatnot. But again, in this case, appellant was found guilty. The matter was referred to the court, and he was charged. Appellant was found guilty and then convicted of 3 charges. And dissatisfied with the court the decision, the appellant appealed against the sentence, but the appeal was dismissed. Okay, on the issue of insulting the modesty of a person, Section 509 basically regulates this behavior. Whoever intending to insult the modesty of a person, utter any words, makes any sound intending that such word amounts to insulting the modesty shall be on offense. This just to show to you this case of PP against Nurhanizam. This is about disseminating an intimate video through WhatsApp group. So accused here was charged under section 509 of the penal code, this one under penal code, for outraging the modesty of his wife's cousin. What happened was the accused took a video of this apa ni, of her while she was taking a bath, and then dia pergi distribute to the family's WhatsApp group. So the and then apa ni, he was arrested lah, and then he was charged in court under section 509. Accused then plead guilty, and the magistrate court sentenced him to 2 months imprisonment. Prosecution was not happy with the sentence, appealed to the High Court. On appeal, High Court stated that in this digital age, information and content can spread in the blink of the eye. So because of this, High Court judge also held the words intrudes upon the privacy to also include recording a person without permission and then distributing the video. High Court enhanced the imprisonment to 6 months from the date of conviction. So this one banyak jadi kan, kita tengok orang macam record video dalam tandas lah apalah kan. So this case happens in a family, in a house. Okay, so that's the end of this topic. So in summary, remember that the obscenity test in Malaysia that we have discussed, and how it differs with other countries, and we also learned about the child grooming, child sexual offences. So those, meaning that the law is there, and cases there are actually, according to the police officers that I have talked to, there are actually hundreds of cases, and because of the coming of the enforcement of the SOAC, though they are able to bring many cases to courts. Before this, they are not able to bring those cases because the law is not so clear on whether penal code lah, particularly penal code didn't say clearly whether child groomingnya, there are several stages kan, especially communication. When the grooming just involve the early stages of sexual communication, that is the most difficult to be established, and to find evidence is also problematic. But let's say if the grooming happens online, I believe the evidence can be found online as well. I mean, we have the police and the cybersecurity can find digital tracks, and then they can find. So inshallah, we pray that law is one of the effort to reduce these social problems. With the more coming of the technology, we don't know how far the technology can be misused, for indecent things. We're looking at a future of virtual reality, augmented reality, and whatnot. So people are concerned, and they are now talking about deep fakes. If you read about this, deep fakes and so on. There has yet to be any law about deepfakes, but if Section 233 is wide enough to cover that in the form of improper use of network facility, then perhaps we can see some development in that. So okay, any question before we call it a day? Belum lagi, Malangkah ada lagi. Any question on this?
So may I ask about in US right now, there's like a platform that was kind of trending right now. It's called OnlyFans, where there are subscribers to a certain channel, and the platform is currently most widely used for distributing this pornographic materials, but somehow it cannot be leaked, and it says on the platform, but it was subscribed. So there was a flock of people being interested to use the platform because of that there being exclusive subscribers. So Does it, if it ever reach Malaysia, would there be any law regulating this?
What is this? Saya pernah dengar nama ni, tapi what is the service all about? Is it like online dating?
It is quite like online dating plus YouTube where you subscribe things.
Okay. We can under our law, I think Penal Code Communication Multimedia Act, it's already there lah to criminalize this kind of content, especially if it promotes prostitution ke ataupun apa if it publishes pornography kind of thing kan. Tapi online dating per se kan, online dating per se, we are not so sure whether that amounts to indecent content. At least lah, kan kita ada indecent content. Uh, because online dating sites, if they can, it can be proven that somehow it can cause or leads to prostitution, then adalah the law relating to prostitution is there. But online dating per se itu, that is a grey area, where people might have been abusing that lah, for immoral activities kan. So what the government or the regulator can do is, if they found that these sites, they are promoting illegal things, they can, under the MCMC, they can block lah, they can block the sites. Which similarly, what has been done to this one site, dating site, tak ingat lah nama dia, tahun lepas ke tahun ni kena block. The site is owned by Malaysian, but the server is not in Malaysia, it's somewhere offshore. Apa ke nama website tu? Yang dulu dikatakan banyak recruit student university. Ingat tak?
Yang sugar baby tu yang
Sugar baby shaper
yeah.
kan. That site is actually owned by Malaysian Chinese. Tapi the server is not in Malaysia. So what MCMC done is they have blocked the site. Of course, the site has been, what I read, they have tried to teach the subscriber how to circumvent the blocking. So of course lah, if you go outside Malaysia, definitely there will be no block anymore. The blocking only applies within the Malaysian territory lah. Dulu saya pernah buat satu assignment dengan student, how do you compare sugar daddy with baituljannah.com. So ramailah yang sokong kata baituljannah.com tu lain gitu. Itu syariah compliant dia kata. Mana kau tahu syariah compliant, kau tak check. Because everything is done by, private kan. It's not open kan. Okay, any other question? Okay, admin, how's your house now?
So far no water supply yet, but I think we are going to get maybe tomorrow.
Okay. Hopefully will be better lah. Yeah. Be mandi kat mana?
Tak ada air semalam je, tu pun cukup-cukup.
Yeah, okay. Any other question? Okay, if there's no question, inshallah, see you tonight. Let's close with tasbih kafarah and suratul as.